No, I mean in general, because it would appear to me that that's your sister. I don't understand. You're an adult, she's an adult, and you start choking your sister. So I'm trying to figure out, how does her not returning your keys result in you choking her or being abusive towards her? I'm just trying to figure out your mindset so I can know what conditions to set for you, because I don't understand. Like why you would get violent with your sister. So why did you pawn her television set?
Ramos for the defendant.
All right, court is calling 2024 CR 007-136, State of Texas versus Dylan Conchos. Can I have parties announced for the record for the state?
Yeah.
Defense?
Fernando Ramos.
And are you Dylan Conchos?
Yes, ma'am.
All right, counsel, have you received all the discovery?
I have, Your Honor.
Did you review it with your client?
We did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Conchos, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
And did you sign it? All right. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, and the court is in receipt of a notice of intent to seek an affirmative finding of deadly weapon. Are you all not proceeding on that?
No, Your Honor.
Thank you, Judge.
All right, Mr. Conchos, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of assault, family choking, or strangulation? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights? Did you understand
Yes.
by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Conchos, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is recommending deferred adjudication, and there's to be no contact with Elva Conchos. And did you understand if the court finds that there is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
And did you understand if the court were to find an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the entirety of your plea? Defense, is that the plea?
It is, Your Honor, except for if I may address the court on the issue of affirmative finding.
All right, we can address that once we come to sentencing.
Understood.
Is that the plea? All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting 3 years deferred adjudication, a TAP evaluation, affirmative finding of family violence, and anger management. Did you understand those were recommendations by the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
No objection, Your Honor.
All right, did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes,
Did you understand it?
yes,
Did you sign it in all appropriate places?
yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review states exhibits 1 and attachments. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Anything you wish to say on behalf of your client?
Yeah, yes, ma'am. My client is 24 years old. He and his fiance are expecting a child. And that is the reason that we're asking the judge not to impose the affirmative finding of family violence because of the second issue that you stated on the record as far as children are concerned, as far as his ability to have his own children with the, in my opinion, horrendous abortion laws in effect. Anything could happen, and it would be very, very bad if he were not able to take care of his own children.
No, he can take care of his own children, but with the affirmative finding of family violence, if there's a custody issue, all things being equal, he's not going to be designated as primary custodial parent.
And that's the
Now, of
reason we asked.
course,
I'm sorry, Judge.
oh, that's okay. Now, of course, if all things not being equal, if the other parent is a danger to the child, I'm sure that the court will not place a child with someone, hopefully, not place the child with someone they deem to be a danger to the child.
It is that word, hopefully, Judge, that we are asking the court not to impose that particular option to eliminate any type of danger in the future of him not being able to be with his own children, and take care of them responsibly.
Okay, no, I mean, he can still be with his own children. They'll make you a possessory, all things being equal, and this is me giving you hypotheticals because I have no idea what the civil courts would do, but it doesn't say that if you have an affirmative finding of family violence, that they will terminate your parental rights. I mean, so I'm sure the law is clear that you will, all things being equal, and you yourself are not a danger, you'll have visitation. It won't stop you from paying child support. But why did you pawn your sister's television? Because in the police report, it says she was moving out. She came to pick up some more things. You wanted the house key back from her, and she said, I'll give you the house key back when you give me my television back. And she said in the police report, she knew you couldn't give her television set back because you had pawned it. So why did you pawn her television set?
I needed the money for rent. Cause she moved out 2 months prior from that. And she was no longer in the lease.
All right, that's sort of a theft. Where are your parents in all of this?
My mom, I don't know where she was. I don't know my father.
No, I mean, in general, because it would appear to me that that's your sister. I don't understand. You're an adult, she's an adult, and you start choking your sister. So I'm trying to figure out, how does her not returning your keys result in you choking her or being abusive towards her? I'm just trying to figure out your mindset so I can know what conditions to set for you, because I don't understand. Like why you would get violent with your sister.
May I respond, Your Honor?
No, I want him to respond. I mean, he was there. I wasn't. I'm just trying to figure out your thought process so I can put appropriate conditions. So why are you putting your hands on your sister in anger? It says that you pushed her against the wall. And
That
then,
was after she tried stopping me from walking away.
that's not what's in the police report.
I understand that.
Alright.
But okay,
No, I'm just trying to figure out in the police report.
yes,
So let's see if we can start, because I found that the truth sometimes is somewhere in the middle. So in the police report, it says she comes over to the house to collect her remaining items.
yes, and they were there. We couldn't.
All right, so she's coming, she collects her remaining items, and you tell her you want the house key back. She tells you, I'll give you the house key back when you give me my television set back. She admits in the report, she knew that you couldn't give her her television back because you had already pawned it. So she has your house keys, and you're telling me that you were walking away, you were just going to let her go with the house keys. Is that what you're telling me? Because in the police report, it says you pushed her against the wall because you were trying to get the house keys that she wouldn't give to you because you would not give her back her TV set. So how does her having house keys turn into you pushing her on the bed and choking her? And I'm not trying to trip you up or trick you.
Yes, ma'am.
I'm just trying to understand your thought processes.
Yes.
Because usually,
I just wanted the key because she didn't belong there.
and it never occurred to you to just let her have the key and then just change the locks.
Well, we did that because she had spare keys and we didn't know she had spare keys.
Then you wouldn't need the key back if you had already changed the locks.
Well, we didn't change the locks till after the incident, so.
All right. So is this the first time you and your sister have had an altercation where it's turned physical?
Yes.
Hmm?
Yes,
All right. State, have you talked with the complainant?
Yes, Your Honor. Her primary concern is just, she wants him to have, kind of an evaluation, which is why we've included the tap. And she just wants to be left alone.
All right.
And she said that she would leave anything else up to the court in terms of how long for any sort of punishment.
All right. Well, counsel, here's my issue. I follow the law.
Understood, Judge.
And the law is that this is an affirmative finding of family violence. It's not, I can't, unless somebody wants me to bring some case law to me that says if there's violence that occurs and it's between family members of people who have or had a dating relationship or married, and I have the discretion to say, I'm not going to do an affirmative finding of family violence, then I'll consider that. But my understanding of the law is either it's an affirmative finding of family violence or it's not. If it's not, then this division should not be prosecuting the case. It should be on the criminal trial division side.
On the other hand, it is not a conviction either, Judge.
I understand. Anybody have some case law?
I say I believe you could, and I would have to double check my case. I believe you could hold it in advance, but that I've had arguments with other defense attorneys before. They like to tell me that it can be held in advance, but I would have to do the research on that, Your
Well,
Honor.
I don't believe it does. If I'm incorrect, let me know. And if I'm incorrect, counsel, you can always come back and I'll reconsider that.
Understood, Judge.
All right. This is what the court is going to do. And I'm assuming he has no criminal history.
Correct.
Court is going to sentence you to 2 years deferred adjudication. There's an affirmative finding of family violence. There's to be no contact with Elva Conchos. Are you currently employed, sir?
Yes.
What do you do?
I'm a via operator, bus operator.
All right, proof of employment. Within 30 days. There's to be no employment as a home healthcare provider or with minors. Anger management. Have you had any drug issues?
No, ma'am.
All right. If you were tested today, what would the results be?
Negative.
All right, we'll do regular random UAs. And I'm gonna want a UA today. No later than 3 p.m. Regular reporting by Zoom or in person. There's going to be 100 hours of community service restitution. I'm going to order parenting classes. Once he completes the parenting classes, the community service hours will be deemed satisfied.
Thank you, Judge.
Field visits, one time per month. For 3 months. And when is your child due?
That I don't know of yet.
Okay. All right. Probation. It'll be field visits one time per month for 6 months. And then thereafter at probation's discretion. And we can do a TAP evaluation out of custody.
Thank you, Judge.
Okay. And there also be a MIC evaluation out of custody.
For my client's benefit to make evaluation.
It's a mental health evaluation.
Thank you, Judge.
Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with
Yes.
your attorney? Did you understand it and sign it?
Yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes,
All right, we can go off the record. In this court, to be successful on probation, communication is key. If you have any issues, just let probation know. If you feel as though they're not addressing your issues, you can always come back to court, okay?
that's fine.
All right, good luck to you.
May I please keep going?
Yes,
Thank you, Judge.
just remain in the courtroom. Probation will speak with you. Jason Gonzalez. All right, court is calling 2022 CR 8756, State of Texas versus Roseanne Garcia. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Will Brooks for the defendant, Judge.
And are you Miss Garcia?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Roseanne Garcia who's placed on deferred adjudication in 2022 CR 8756 for the offense of possession of a controlled substance penalty group 1, less than 1 gram on March 20th, 2023 for a period of 2 years? Is that you?
Yes, Your Honor.
State.
Yes, Your Honor. Violating condition number 1 on or about the 18th day of May, 2024 in Surrey County, Texas, the defendant Roseanne Garcia committed the offense of possessing a controlled substance penalty group 2, less than 1 gram, violation of condition number 1.
Just one moment. Is there a supplement?
Notice?
I don't believe so, Judge.
All right, so you said possession less than 1 gram?
Yes, Judge.
Yes, Your Honor.
All right, what I have is criminal trespass. This is the only thing that the court has.
What I have. That's odd.
That might be an old MTR, Judge.
This is September 6, 2023.
All right, thank you. That's what I had. Okay.
Okay.
All right, how do you plead to that? True or not true?
Okay.
How do you plead to that? Violation, true or not true?
True, Your Honor. Your Honor, we waive the remaining violation.
No objections, Judge.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility
Yes,
and up to a $10,000 fine?
Yes, Your Honor, sorry.
No problem. Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true Is there a proposed agreement?
There is, Your Honor, and that is to enter adjudication on this case and revoke the individual's community supervision. Sentence her to 9 months in the state jail facility. And the state will be taking into consideration night mag number 765-745, which is the case you just read true to.
All right, is that the proposed agreement?
Yes, it is, Judge.
All right, what has she done on probation?
We actually did complete residential treatment, Your Honor. Although this case was picked up very soon thereafter she was released. And
That's about it.
All right, are you asking the court to follow this agreement? Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will find you guilty. The court will sentence you to 9 months in the state jail facility, give you credit for any time served. Take in consideration night mag number 765-745. Is there anything else?
The judge would just ask for credit for time she was in custody, which should cover it. She did go to ISF for a period of time, which may not be reflected in the court system.
All right, unless legally I'm required to give her credit for when she was in inpatient treatment, I'm not going to give her credit for that.
Understood, Judge.
Okay. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And I'm going to ask for therapeutic community. I cannot force them to place you in the program, but you'll need to ask for it as well. It will not increase the time that you're in custody. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. Sometimes I'll give people credit for time that they've been in inpatient treatment, but what I'm being told is you may have successfully completed inpatient treatment, but you immediately left inpatient treatment, didn't use any of the tools that you had not to use again. You're just like, okay, I'm just doing my time, doing my inpatient treatment, and you immediately leave and you pick up another case. You understand?
Yes, Your Honor.
All right, you're gonna have to make better choices. Otherwise, sometimes the last time you use is the last time you use. And if you have children or family members, I don't think you want them on the news having to come down and identify your body because you've got a bad batch.
This case marked the end of a second chance. After violating probation, the defendant stood before the judge and admitted the violation, knowing it could mean prison time. The court reviewed the history, the failed treatment, and the new offense. Deferred adjudication was revoked, guilt was entered, and the sentence was handed down 9 months in state jail. The judge's warning was direct. Treatment only works if you choose to change. Without that choice, the consequences are final. Do you believe the court gave fair warning, or was this outcome inevitable? Share your thoughts below and like and share for more real courtroom moments.
But whenever I see you, I see there's a connection between
That's right.
you and
That's right.
LaShawn with the Pittsburgh Steelers. Y'all share that connection.
Absolutely.
I don't know how people in San Antonio feel about that, but you know.
I see
it's
a lot of,
great.
I see a lot of Steelers flags.
Yeah. Well, you know, I used to wear the Pittsburgh Pirates uniform when they had the B hats sort of.
Oh, yeah, yeah, yeah.
Yeah, those were great uniforms. I
They
don't care
were.
what anybody says.
They were, they should bring them back.
Yeah. All right, the court is going to call 2024 CR 00744. State of Texas versus Jesse Demas. Can I have parties announced for the record for the state defense?
Roberto Amorosino,
And are you Mr. Demas?
This one,
All right, is there something wrong with your eye or something?
he recently had a stroke. There was a report to the court. He was in the hospital for about a week and they brought him back.
All right, does he need to have a seat?
no, I'm fine.
You sure? All right, well, let us know if you need to take a seat. All right. Counsel, have you received all the discovery in this case and did you review it with your client?
I have,
Court will find that the state is in compliance with discovery. Mr. Demas, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes,
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
And are there any applications in this case?
There are not.
All right. Mr. Demus, did you review the document entitled Court Admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Sir.
Did you understand you're charged with the offense of theft of property, $2,500, less than $2,500, with 2 or more previous convictions?
Sir.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea?
Yes, sir.
If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, sir.
Did you understand by entering this plea, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Demus, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's to be 104 days in the Bear County Jail under 1244, and there are no applications. Did you understand that to be the plea?
Yes, sir.
State, is that the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
There have not.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
Contained in exhibit. attachments,
No objection.
State you may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes, sir.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right. And just for the record, in the report, in the police reports, he's listed as Jesus Demas Jr. On the docket sheet, he's listed as Jesse Demas. And in the indictment, he's just listed as Jesse Demas. So the Jesus Demas, State, could I have you for one moment, please?
Just serious.
So the person who's listed in the police reports, and I'm going to rescind my guilty verdict for now. The person who's listed in the police report is listed as Jesus Demas Jr. And in the indictment, it's listed as Jesse Demas. So there needs to be a correction there.
He indicates that his
Jesus Demas.
legal name
They
is
always
listed.
use just, I don't know why. They say it's the same as Jesus.
And
All
we
right.
would not object to the indictment being amended to reflect the name change.
And Your Honor, the state would like to request that the indictment be amended to reflect Mr. Demas's correct name, Jesus Demas.
All right, any objections?
No objection.
All right, Mr. Demas, do you understand that the changing of the indictment from Jesse Demas to Jesus Demas Jr. is a substantive change to the indictment?
Yes.
Knowing that, do you still wish to continue with this plea?
Yes.
In defense, are you waiving your time?
Yes, Your Honor.
All right. Thank you. You may be excused.
Thank
All right. So then the court will find the defendant guilty. Are we proceeding with sentencing?
Yes, Your Honor.
All right, Mr. Demas, why are you continuing to steal?
I've been trying to get disability now.
I'm sorry, what?
I've been trying to get disability now, so I'm just making bad choices.
But that doesn't mean
You know,
you steal. I mean, this is the third time. Here's the thing. I know that the state is probably, I wasn't in the negotiating room because I'm not allowed to. I'm sure that one of the reasons that they're probably offering you this is because you've had a stroke. But you must stop stealing. And I'm looking at the items that were stolen, and it's batteries and buckets and I don't know what this other item they have in the cart. But a reservoir, but you must stop stealing. And because people fall on hard times, that doesn't mean you get to steal.
I understand.
What if I fall on hard times? And honestly, I have been on hard times. I think your attorney and every person here who's an attorney can tell you,
Yeah.
unless they were trust fund babies, when they came out of law school,
Mhm.
the only thing they had in their pockets was lint. So guess what? If all of us would have got together and said, hey, we're poor people because we just graduated from law school and have these loans, and we decided to go stealing, I would have told your attorney, go to Walmart. I'm going to hit Target. You hit this place for clothing. We need some suits and some clothes to appear in court. What kind of society will we have? So there's no excuse. Do you understand? All right. Court is finding you guilty. The court will sentence you to 104 days in the Bexar County Jail under 1244. There's to be no contact with Home Depot. And the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And you need to follow through on the the rehabilitation they're telling you to do with regards to that. Do you understand?
Yes, ma'am.
All right, good luck. Thank you.
Thank you, Your Honor. Good luck.
Your last name?
Sue Lynn King, AING.
All right, you may proceed.
Ms. King, I was appointed to represent David Lopez, and you understand what he is charged with, is that correct? He's charged with aggravated sexual assault of a child, and you've seen the indictment. He's also charged as a repeater, is that correct?
Yes,
And have we talked about that repeater allegation?
yes,
Have you seen the judgment of the repeater allegation?
yes, I have.
And is the picture in the judgment of David Lopez?
No,
Is the date of birth of David Lopez?
no,
Is the height of David Lopez?
no,
Is where he served and he was ultimately found guilty in Harris County? In your knowledge, has David Lopez, your David Lopez, ever been to Houston?
he's been to Houston, but he never lived in Houston.
Has he ever been to prison?
No,
Okay, so the repeater, when he got placed on bond, this bond amount reflects an aggravated sexual assault of a child with a repeater allegation, correct?
yes,
And he's out on $100,000 bond?
yes.
How did that?
I'm sorry, just on my, excuse me. Did you clean up the? Thank you.
If you-
Ah. I have a copy. No problem. Thank you. All right, you may continue.
Now, you understand the allegation against David Lopez, is that correct?
Yes, sir.
Who is the alleged victim in this case?
My granddaughter.
And you took over custody of your granddaughter. Why?
They were in foster care due to.
Let me stop. They,
Caseworker, they're supposed to be objective. And I want to hear from them rather than just reading words on a page, because sometimes I have questions. So do y'all want to see if you all can call the caseworker? I'm sure they would zoom in.
state.
And then if you want to continue with your questioning of her, I'll listen.
I believe the judge kind of cut to the chase.
Yes,
You want David at home.
yes,
Do you need David at home?
we do need David at home.
Do
I'm
the-
a full-time nurse. I work sometimes up to 16 hours a day, 6 days a week. And either his parents are also in the home, the grandma. they're also in the home, but they're 83 and 85. And they cannot physically handle the two youngest girls because sometimes whenever their mentation strikes, it gets completely out of control. David handles them, sits them down in the living room, turns on a movie in the living room, kind of keeps them all pretty much stable. Phoenix comes down, she sits in the living room on the couch on the end and watches TV with them. It's a family interaction. I can see everything they do in the house.
Let me ask you this, has David ever alone with Phoenix?
Never alone with Phoenix.
Are there cameras that there are boundaries in the house?
There are boundaries in the house. If David is downstairs by himself, Phoenix does not come down because of the interaction whenever Phoenix had it first. And then David being accused, we don't want that accusation to be able to be brought back up.
And lastly, has Phoenix made an allegation where it is clear that David is out of the house and it could not have happened?
There have been a couple of times whenever David wasn't even in the house, he was at work or he was busy with the church working on beds and stuff, where she said that he's done something and my son's been present in the house and has told her that didn't happen. He was in the backyard working on a playground for the younger two, and she accused David of something that he didn't do because she'd never been outside and David was only outside, and she accused him at the time he was working on the playground himself. Joseph was on the back porch watching, and she blatantly made an accusation against David that didn't happen.
In your opinion, do you think the children are safer with David in the house than David being out of the house?
Yes, I do. I think that they have developed such a relationship that taking David out of the house, the youngest one actually reverted back to peeing on herself and peeing in the bed and unable to focus at school.
And how old is she?
She's 9, with limitation about a 3 to 5 year old child.
All right.
Other questions?
Any questions, State?
Yes. So when David was arrested for this back in 2024, was that when that
Yes.
out of county?
Yes.
And since that time, since 2023, he's been in the home with you and Phoenix.
Yes.
Even after these allegations came out.
Yes, because the courts cleared him. Or not the courts, but yes.
Right.
All right, so I have a couple of questions. Are there any objections?
Not really sweet.
None from defense, Your Honor.
All right, so you say there are cameras in the house. Where are the cameras?
There are 3 just down the hallway for the girls.
Mhm.
There's one in the corner above the bathroom that looks at the youngest children's door,
Mhm.
because Mia sometimes has the tendency to come out of her bedroom and fall down the stairs.
Okay.
So there's a camera there and it triggers whenever somebody exits their bedroom. There is a camera in the corner of the hallway looking exactly this way, down the hallway where the gate is, down the hallway here where the girls' room is, and on Phoenix's door with the back.
So, correct me if I'm wrong.
Uh-huh.
So the only places there are no cameras are inside the bathrooms,
There are no cameras in the bathrooms.
but do cameras show anyone who's going into the bathroom?
Yes. And there are SD chips in each camera, so we can record and document anything that may come out as an accusation. There is also, because Phoenix was suicidal at one point, she doesn't have a door on her bedroom because we had to watch her closely. For 2 weeks, she was on suicide watch before she went into the institution.
Mhm.
And so there's a camera directly on that bed alone. She has privacy everywhere else.
So how many children in the household that are underage? And those are the 3 children that you took into your home?
Yes.
All right, and how many adults are in the household? All right, and who are the 5 adults?
My son, he's 30 years old. He is upstairs with the girls when they come out of the gate. His bedroom's right there.
Okay,
My father-in-law sleeps on the other end where the children's playroom and TV room is.
okay,
And David's mother, who is downstairs at the very front of the house,
okay.
and then me and David.
All right, any other questions?
Yes, Ms. King, The two younger children, they're nonverbal, is that correct?
Oh, no, they're not normal, they're very verbal, they're very high functioning.
I functioning.
Yes.
No further questions.
Yes.
Just for clarification, Phoenix did go into inpatient care for how long?
She was in for 7 months this last time at Cedar Crest Hospital.
Okay, and so if she gave any indication whether this did or didn't happen to them as
Yes.
well, you weren't around.
I
they could
wasn't
talk to
there.
her. And lastly, the state says that David was arrested on in 2024. It was actually March 19th of 2025. Is that correct?
That's right.
Okay. That's all, just for.
All right.
That was the other place.
And other than this child, have any of the other children accused him?
Accused him? No, Your Honor.
They
But
accused her.
they are verbal and they accused Phoenix of
While she
acting
was
out.
institutionalized,
Okay,
and she knows that she did it. She will tell you.
okay. All right. So if y'all can have this, the caseworker zoom in, the court will make its ruling.
Thank you, Your Honor, very much for your consideration.
Sure, you're welcome. And if you talk to Norma, once you have the number, she'll give you the Zoom link. Anyone else ready?
This was not a simple courtroom moment. It was a family caught between protection and accusation. Serious allegations. Years of CPS involvement. Cameras installed, boundaries enforced, and a child whose past trauma complicates every answer. The judge slowed everything down, refusing to rush, refusing to guess. Instead, demanding facts, oversight, and the voice of CPS before making a decision that could reshape an entire household. In cases like this, justice isn't loud, it's careful. Do you think the judge made the right call by pausing and demanding more oversight? Share your thoughts below and like and share for more real courtroom moments.